Rule 128, General Provision, Section 1, Evidence. Evidence is a main sanctioned by the rules ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 2, Scope. The rules of the evidence. The rules of evidence shall be the same in all courts. The same of the old courts. It's all trials and hearing except as otherwise provided by law. Section 3, Admissibility of evidence is admissible when it's relevant to issue and excluded by the Constitution. Section 4, Relevancy. Section 4, Relevancy, Collateral matters. Evidence must such relation in the fact issue as the include belief in extends evidence on collateral matters shall not be allowed except when each tender in any reasonable degree to establish improbability of the fact. Rule 129. What needs to be proved? Section 1, Judicial notice when mandatory. A court shall take judicial notice without an introduction of evidence, extends the territorial extent, state political history, forms, government symbols, nationality, norms, admiralty, and maritime court. The political constitution and history of Philippines and geographic division. Section 2, Judicial notice. Section 2, Judicial notice when discretionary. A court may take judicial notice. A court will take a judicial notice matters when public knowledge or any capable, unquestionable demonstration or oath to be known to judge became of their judicial function. Section 3, Judicial notice when hearing necessary. During the trial, the court modo proprio or upon motion shall have a parties on the proportion of judicial notice of any matters. Section 4, Judicial admission. An admission oral written made by the party in the source of the proceeding in the same court in the same case does not require proof. Rule 130, Rule of admissibility. Section 1, Object as evidence. are those addressed to the sense of the court. Upon an object is relevant to the fact in issue, it may be exhibit to examine or viewed by the court. Section 2. Documentary evidence. Documentary evidence consists of writing, record, materials, photograph, contains letter, word, sounds, figure, and number, or symbol. Their equivalent or other mother of a written photograph include still pictures, drawing, image, films, X-ray, and videos. Rule 131. Burden of proof. Burden of proof, burden of evidence, and presumption. Section 1. Burden of proof. A burden of evidence and burden of evidence. Burden of proof is a duty of party to present evidence on the fact in issue necessary to establish his or her claim or defense. The evidence required by law. Section 2. Conclusive presumption. The following are instance of present. The following are instance of conclusive presumption. Whenever a party by his or her declaration, act, or omission, intentionally, deliberately, particular such belief. Any litigation arising declaration the tenant is not permitted to deny the title of his or her landlord at the time of consignment of the landlord